Ladies and gentlemen of the jury, I'm not asking you to lock him up and throw away the key. What I'm asking is that you impose a legally allowable sentence at the conclusion of this proceeding where he has been given the due process that we all enjoy in this country. These are the sentences that you are allowed to give: 20 to 50 years. In this case, his parole eligibility would be 85% of the sentence, but will cap with a parole eligibility of 20 years. So once it passes 24 years, for the rest of that, 25 years, 40 years, 50 years, his parole eligibility is 20 years. So he meets the board in 20 years. Life, where the parole eligibility is also 20 years. Life without parole for 25 years. So it's a 5-year difference between that life and this type of life. And then the final possibility, life without parole at all. And that is what we are asking for. We are asking for that for a number of reasons that I will go through here. Obviously, you also consider whether these sentences run concurrently or consecutively to each other, and you consider the sentences for the other crimes. I'm going to focus on this because this is obviously the bulk of what we're talking about here. Now, when you are making a determination, as you see from your instructions, you are allowed to consider the things that you have heard in the entire trial. You are allowed to consider the horrific nature of these murders. You are allowed to consider the effects on the family. You are allowed to consider Christopher Jones, father of 3, grandfather of a granddaughter that he never got to meet, beloved brother. You're allowed to consider Larry and Maurice, sons, grandsons, brothers. They have a little sister they never met named Larissa, for Larry and Maurice. Their lives cut so tragically short. You can consider all that. And yes, you can consider the mitigating factors if you believe them to be true. Now, one of them listed here is that at the time of the offense, the capacity of the defendant to appreciate the criminality of his conduct or conform his conduct to the requirements of the law was impaired as the result of bipolar disorder or other mental illness, and you heard from Dr. Allen that that was not true. And Dr. Allen is an expert, just not in the administration of IQ tests, but none of the people you heard from today administered IQ tests to the defendant. Dr. Allen, as opposed to the other 2 experts, did have the opportunity to observe the defendant, to speak with the defendant. And he concluded that to the extent that the defendant had bipolar disorder at all, if that was even true, he was not actively suffering from it at the time of these murders. He was not impelled by bipolar disorder to commit these murders. He was not in a manic episode. He saw the interview that occurred 2 days later. You saw the interview as well. And Dr. Allen told you that mania is apparent to even a casual observer. And you could tell from your own observation of that interview that he was not excited. He was not suffering from some compelled need to speak. He was calm. He was answering questions as you would expect somebody in an interview to answer. So you can consider this. I would ask you to consider the veracity of it and find that it is not true based on Dr. Allen's testimony. The same for C. I'll skip to C, and that is that an intellectual disability caused him to be unable to appreciate the criminality of his conduct or conform his conduct to the requirement of the law. Now, there's no doubt that there's some intellectual challenges here. The experts disagree on the severity of those. You've heard that it's hard to get an actual read because of his lack of effort. The IQ test, the earliest one, when he was 10 years old, showed an IQ of 90. The flood effect for 86, taking him into the low average range. And Dr. Allen told you you can't fake up, which indicates that 90 down with a range down to 86 would be a more accurate representation because that is the highest one. And that is before he had motivations. And all all the subsequent tests, they were things like trying to get disability benefits, or when he was 16 and in school, or when he was facing criminal charges. So he had reasons to put in less than a full effort on those tests. But regardless of what his level of intellectual talent is, he still had the capacity to appreciate that this conduct was wrong. He still had the ability to make different choices about this conduct. And so, based on what Dr. Allen told you, I would ask you to cross out C as being untrue as well. Now to return to B. At the time of the offense, the defense acted as an accomplice in a capital offense committed by another person. He was the one that was directing these crimes. They were the accomplices to him. Sure, take into consideration their sentences. They each got 10 years. Ja'Cory served until he was paroled. Anwan, at his 18th birthday, was placed on probation, and we'll see what happens down the road from that. But this total sentences were 10 years on charges of facilitation of murder. So that's 10 years for being forced by Brice Rhodes to take a knife and stab people that he had already killed. Yeah, they should have said no. They should have banded together, tried to get out of this situation. They should have, when he left from there to clean, run out onto Brownsboro Road and flag down a car and ask that driver to call 911. They didn't, and they're paying a price for it. But if they want you to consider those charges, those sentences relative to what he should get, 10 years for being forced to make 2 or 3 stab wounds, what does he get for 21 stab wounds for Larry? 8+ for Maurice, shooting Christopher Jones. A lot more than those boys got. D is the youth of the defendant, if you consider 26 to be young in this context. Any other circumstances? You've heard about his childhood. This, I believe, cuts both ways. No child should have to see his mother be the victim of a domestic violence situation. That's awful that that happened. And that's probably why we see some domestic violence charges in his history. That explains that. But also, there were parts of his childhood that he could have turned to make different choices. He had a loving stepmother. Sounds like his father was very involved. Not all children get trips to Disney World and get read Harry Potter at night. So I don't know how you choose to weigh that. A lot of what we know from these last 2 days come from reports about what happened. For instance, we've heard no direct testimony of what exactly was going on with his mom. We've heard what his stepmother told the interviewers was happening with his mom. So weigh that how you will. And again, I'm not saying that there wasn't trauma in his childhood. But there's nothing from that that indicates he doesn't have control over his decisions, over the choices that he made in this case. So you consider the mitigating circumstances that you believe to be true. And there's no system in Kentucky where you add some points, take away some points based on, like 3 years for this, minus 5 years for that. No, you just consider the whole of it as you decide upon where in this range you choose to fix the penalty. The aggravating circumstance that is listed here is whether you believe that the defendant committed the offenses of murder intentionally and that they resulted in multiple deaths. And this is something you considered 2 days ago when you were deliberating, that these were intentional murders, and obviously they are multiple murders. So hopefully that won't take you that long to reach that same decision. And what that, under the law, what that allows is these 2 additional penalties here that wouldn't be allowed if those were not the case. So if you don't find that to be true, these would be your choices. If you do find that to be true, you will also get life without parole for 25 or life without parole. And again, I believe that you have already found this. I hope that you will continue today to find this aggravating circumstance to be true. You are allowed to consider his past criminal conduct, which started when he was 18 with intimidation, 3 counts, possession of a handgun without a license, for which he got 4 years. He also, around that same time period, committed 4 counts of armed robbery and criminal confinement, for which he got 12 years, but was probated. And that is of interest to us because he later violated that probation. In 2013, which he would have been 22 then, his birthday is September 1st, 90, so that August he would have been 22. He committed an assault 4th, domestic violence. He violated his probation twice in that case. At age 23, he committed 2 counts of battery resulting in bodily injury, received a 1.5 years, violated his probation in that case. In 2014, so age 23, assault 4th, domestic violence again, and he violated his probation in that case. And at age 25, he murdered 3 people. The government of 2 different counties gave him chance after chance on probation, and every time he violated that probation, he was not able to live under the conditions of probation or parole without being brought back to court and revoked on them. Chance after chance, and it didn't stop what happened here. And that is one reason that I'm asking you to give a sentence of life without the possibility of parole, because we already know that that did not, the supervision of the probation and parole offices of 2 different counties did not reform his actions and did not stop this from happening. So you are allowed to consider all of this. So then you just go through the instructions just like you did on Monday. They're all listed here. Verdict form number 1. You pick if you do or do not find the aggravated circumstance of intentional multiple murders. And then on the corrected copy, you will see that there is a list where you check which one of those penalties that you believe that it should be. I don't know how a family processes the loss of any loved one to violence. I'm sure you never fully get over it. But at least the family of Christopher Jones can say to themselves, at least it was quick. The last thing, he was still conscious, the last thing he heard was Officer Franklin saying, "Hang in there, buddy." The last thing he felt was Officer Franklin holding his hand. The families of Larry and Maurice had no such peace. Their deaths were not quick. They were not quick in anyone's hand. They each died alone and betrayed by people they trusted. They each died knowing the other was somewhere in that room and not knowing what would happen to the other. They each died horrific deaths. And I do not think that the Wren family, the Ordway family, should ever have to go to sleep at night not knowing where Brice Rhodes is. There are multiple reasons for the prison system. Rehabilitation is one. Punishment is one. Removal is one. And I would argue that the 2 latter are what is most important in this case. I don't want you to punish out of passion or anger, but out of justice for what he did to these 3 people and to their whole family. ask you to remove him for life without the possibility of parole, so that they never have to worry about this again. Thank you.